Good morning, Nigeria. Nice to be in the program with Go Small. I deal with our brother, Dr. Daud. Good morning, Doctor.
Thank you very much, sir.
Yes, so make we know the position of the law. Abuja topic for the last presidential election, we say Tribunal just now. From what the judge don't talk now, my brother Aaron about just do your submission just now. Make I also ask you. Does it mean say Abuja and Dom become state when we say they go come go vote for and that we can't get governor like every other state for this country?
No, Abuja not be a state in successor to now have governor or can't get commissioners. No, not be so it be.
But Abuja, what did judge may come talk?
I go tell you what did judge talk.
Okay.
Because what did judge talk? Election matter. For English, there is a sui generis. Anything where it be.
See me come here.
Yeah, now what did the law talk? Now they go tell people. Whatever even to people they make noise so settlement so emotion so election matter not be like that. Election matter say what did the law talk? First, the issue where people talk say you go score 25% for Abuja. Now imagination, in no day law, no day book of law. In no the constitution, there is nowhere in the constitution where they talk say you must score 25%. You know the section where they refer to section 134 or anywhere in the constitution. You know they there like that.
What did the constitution talk?
What did the constitution talk say? He say for person to win presidential election, he say first you go score the highest vote cast. That be the first abject. That be the first leg. You go score the highest vote cast. He no stop there. He can't say if you don't score the highest vote cast, that highest vote cast alone will not be enough for you to win. You must mean say you have a spread across the country where it is 25% in at least 2/3. 2/3 means of the country. It no mean of the 36 states. It means because Nigeria today now is divided into 36 states and Abuja, which was not the case in 1979 because Lagos were the capital that time. They know they call our federal capital territory. They call it the headquarters of Nigeria because it was also a state on its own. But Abuja now is not a state on its own. You no get governor. The governor where they Abuja now be the president. The minister where they Abuja now be the minister where they appoint for today now weekly. Just as each state get minister. So by interpretation, the president represents the governor of Abuja, while the minister represents the minister that represented all the state. So when you now say take 25% of 2/3 of Nigeria, it means you take it as a whole. You don't go first of all say, let me do 25% of 36 say first. When I don't do that one, if I don't get result, and I go and do 25% of 2/3 of Abuja, not be so you talk. You must first all get the whole. The question now that what will be the whole of Nigeria? If you add Abuja journal, what it will be? If you say Nigeria be one, you are taking it as a whole. You want to take percentage from it. It means before you can take that percentage, you must first of all determine what is the whole before you take your percentage. And the whole means 36 plus 1. And the plus 1, it will give you 37. And it's from that 37 you go take your 25% of 2/3. You cannot first of all say, let me take 25 2/3 of 36 state first. I go leave Abuja for there first. I'm not going to take a journal. When I don't calculate the one of the state, I put on one side, and now go Abuja, go to 25%. That means you are dividing the country into two on equal parts.
Okay, that is it. So say when you want to take the 25%,
it must be of the whole country.
Of the whole country.
Because the country is made up of 36 states and Abuja.
Yes.
So you are taking the percentage from the whole country, not say first of all take from one part before you can add the other one. Jonah, no. You must add first before taking. You must say, okay, Nigeria, what will it be? Nigeria be 36 states and Abuja. And what did that one mean for mathematics? Not 37. Because as we speak now, there is a minister representing Abuja, just as minister represents the states. So but people can't say no, you know me say you go do am. Say what you go first do, first take the 25% of 2/3 of the statistics states, before you now take Abuja on its own. No, the country is one. You take it as a whole. It's from that whole you take your 25% of 2/3. And if you take your 25% of 2/3, it's 25. Actually, it's 24.6. But because they do approximation, it will be 25. So 25%, anybody when fees got 2/3 of 25 will win the election. In this election, the way that they talk, so now only one person scored something like that. Now let Tinubu now score. He scored 29. He scored 12 of 29 states. Now, the two people where they challenge him, the first one, where he comes second, which is Atiku. Atiku scored 25% in 16 states. He said me they declare a winner. He no say he scored higher vote. He no say he scored 25% of the highest vote. He said me they declare a winner. Now, this third person, where be Obi, he scored 19. He never get 24. He also did not take or say he scored higher number of votes. He no talk so. Because the law say you must first of all score higher number of votes.
So on which basis are two of the constituencies?
We don't know. Now people tell them when they go court. Say first they have the belief say they say Tinubu no qualify. They deceive, they say Tinubu no qualify. Because he no qualify, they go first of all disqualify him. If they disqualify him, then we go do rerun between Atiku and Obi. They never say that. Even in the prayer, they didn't say make they declare. They say they win. The second aspect, they say INEC no transmit result. How they supposed to transmit it? And I saw INEC don't bring their own law. Since INEC don't bring their own law, make they go to a committee court talk say they breach their law. But they forget say not be so be. The constitution have already empowered INEC to be independent, to take decisions on their own without interference from anybody. And if they say they take decision will do what is called hardship. It go work in justice. They go reverse the decision without any fear of favor.
Without they don't go refer to anybody or go to
no, because if you say you want start, for instance, now that time where they say they not transmit election result, they will say okay, maybe we wait to maybe we first of all go conduct the party. Now that we no fit transmit, maybe problem dey the network. Sometimes you want call me and you no fit call me. You send me text message, you don't assist, you no drop. Sometimes somebody go transfer money to you, you no drop. You say no, since we no fit transfer the thing, no go. Make them wait, make them go call party first, make them ask them what they go do. Therefore, if you do something like that, you have it affects with the discretion conferred on them by statute. The law gives them discretionary powers. There is a discretionary powers given and vested in the INEC. If you go say, mean they don't use the discretion, mean they go ask party, it means they have fettered their discretion. They have allowed people to now be detected to them what they go do. Then the independent is therefore obviated. That is the independent, the way they say they get. You know, called they there. Because them by themselves don't subject that independence to another person to tell them what they go do. If the people say, no, as it be said, no, another result again, or till na wait, if na, or till they fix this thing, we not go transmit result. But what they call the look is that the non-transmission of the result, if they don't transmit them with the electronics or the way they talk, whether does it affect the result that they got from the polling units? Say because they don't transmit them now, it affects say waiting they supposed to transmit from those states, not be they can't transmit at the end, or not be they take hand carry go there. This guy is the question. It is only when you are able to prove that, for instance, in those states I score 100, but waiting they carry go Abuja na 10. Hey, you will not take court.
How you want to know say you score 100?
Yes, because each party, they get what they call polling agent. They also get polling agent for unit, for ward, for local government, for state. So the result where they stay before they collect and say APC get this one, PDP get this one, they get their agent there. So when they finish, APC they will give their party agent. Say that is the state coalition agent for the party. They have what is called state coalition agent for the party. They will give them. APC, where you dey, sign your own, take. PDP, they give them. It is from there that they report to their situation room. They go in party, go where they call situation room. So from there, you don't already tell your situation. They say for Edo State, oh, now we win. We score so number. They go say scan, snap and send to us. They go send them. They go collate. So each party at the state level already have the collation results from the state before the one they are announcing. They know.
Okay, one of your colleagues going to tell the justice say it will slow make it hurry.
You know, election something, not be maybe na tire. Now our brother for this side, and after sitting for almost 11 hours or thereabout, I beg nobody will no go tire. So now out of tiredness, not be say he no. Say the judge must say because
was it pre-switch? Which of them could tell one of the justices say he contradicts himself?
No, you see, when you know say for matter like this, people go talk their own, but the judge know where they go. The judge, for law they say, the law, now the prophecies where the court will talk are nothing more pretentious. It no matter what you talk, no matter what people they talk, they want to see the prophecy. And what will be the prophecy? They go tie up to the law. That is what they call the spirit of the law. What will be the spirit of the law? What did the law talk? What is the law contemplating when they do this thing like this? Until you tie it to the law. Any talk when people talk, oh, you not see the judge now, he no can talk. If you look at all the issues, the judge were painstaking. All the issues that were raised, they take them one by one. I must tell you, in the history of Nigeria, the judgment they give for this one is the best judgment ever. Because they don't leave any stone unturned. Okay, may you put man for the qualification of president and the one we say Oga Shetima no qualify. You see that one also, apart from say the court don't talk, say na pre-election matter. But I want to tell you, sir, the law of nomination say if they nominate you for one position first, maybe they nominate you for Senate, for instance, as in the case of Shetima. And maybe another thing they could nominate you for maybe governor, or as in this case, vice president. The law say that the first one extinguishes on its own. It is extinguished without resignation. You don't even need to resign it. That's why when they say they even resign, take that paper. That is surplusage. You don't need to resign. You don't need to write to the party say he don't resign. Because now the party where first nominate him for Senate, now he nominate him again for vice president. And they know say he cannot be starting an election in the Senate seat and be starting an election in the presidential seat. So automatically, the earlier nomination for Senate extinguishes by fruition. Okay, so what of the corruption charge now against president? No, you see, the corruption charge against president, they say na abroad. I want also give my dimension. I don't want to follow what the court will talk. Because what the court already talk is already obvious. But I want to give you another dimension. The corruption when they talk, for let's even assume say not true. Let's even assume say not true. The decision of that court is not binding on Nigeria jurisdictional jurisprudence. It's persuasive. The matter was not decided in any criminal court in Nigeria. And I saw the decision there is not binding on Nigeria, assuming it's correct. But let me even go to the issue so that people don't go say this man say you know they bind and assault, even though somebody do something somewhere. No, that is not even the issue. The issue of corruption when they say Tinubu do, na lie. Not be so what happen. What happen? See they say the bank, not be even here when money dey, say make the bank forfeit the money, even though the money belong to them. Make the bank forfeit the money because the bank no follow the procedure and not him. So law say if you look at the judge, he says the forfeiture, which is even civil, was not personal, was in rem. That is, it was not made against him, but made against his bank. So it was not at all point of purposes, there was no criminal charge against Tinubu for any court. You know they. And if there was even a charge, there was no conviction. In no day. So mere allegation, mere speculation without more, it goes to no issue in law. Because I was seeing, but they hear the judge when they talk mere allegation. Yeah, because if you do allegation, you go prove them. Whoever assert for law, they say whoever assert must prove. It is not enough to assert. Because as they go now, somebody feel hold me now and say I thief is something. It's not enough to you to just crucify me. You must first of all, maybe you arrest me, you interrogate me, you go check my house, you go check my farm, you go check my workshop, or you go check my law office to know whether or not what they talk or you have a trace. Before you go now say, okay, there is what they call prima facie evidence. Say on the face of it, we believe say this man do something, let us now go and try him. And even in the trial, you must secure a conviction before you can now rely on it to now say, oh, the man really do him. But if it is not, now let me also tell you, sir, so that people will understand. Assuming but not conceding, say Tinubu do what he say they do. Say, oh, they charge them, they did this one. It is not an evidence that can be withheld against it by the rules of evidence. Evidence of bad characters is inadmissible in any law. It's not admissible in court. Except evidence of previous convictions that relates to the matter in issue. And if you look at the electoral law and the issue of say money, they are not connected. It can be relied upon, assuming he was even convicted. If I was the one that was going to argue the court, even if they say he was convicted, evidence of bad character is inadmissible in law because it's going to prejudice the court, the mind of the court against the accused person. If you admit, say, because the person do something before, may you just use that one to convict him. It means say you have not given him a fair hearing in this present matter. So evidence of previous conviction that is not related to a electoral matter, it cannot be committed upon him, assuming that he was actually true that he was convicted. I'm telling you, this is another dimension now. Even though they say they didn't convict him, so they say he got fraud something. In a electoral matter, it's inadmissible, and I may talk so. By the grace of God, not me say I'm proud. I think I don't study law this way they study and reach. I don't study and reach like that. So if I talk, not me say I just talk because I want to talk.
Okay, that's
so even if he was convicted, such conviction, they are admissible.
By the grace of God. So we will relate your PhD to this law.
That's now for law I get them.
Okay, now law you get the PhD.
The PhD when I get. Now so, for law I get them.
Viewers, by the grace of God, this is our brother. It's not just legal practitioner. He get PhD for law. So he say this talk.
Yeah. Now authoritatively, now they talk so. At the talk say evidence of previous conviction not related to electoral matter, assuming but not considering Tinubu was actually convicted, it could not have been admissible. It's an inadmissible evidence against him in electoral matter. You know, it cannot be a basis.
So now, conclusively, Oga Atiku, what about all the one we say carry go?
You know, I go advise, but if I advise, my advice would be unpopular. They go say, you know, say they must go Supreme Court. If I go advise them, you see, government is for everybody.
No, before you advise,
okay.
The things when Oga Atiku take care and go court.
Atiku, you see, Atiku did not have any strong anything. He did not talk anything because he even scored 16%. We don't know what he got to go court. The only thing where they hang God say they go disqualify. They never, none of them talk say they win the election.
What Atiku say they disqualify? What he
the
academic paper?
No, he dey rely on say they convict the man before. And the second aspect say he say the school where he go. But he forgot that in electoral matters, the constitution already provide for the qualification where you need to go. No other person can impose another qualification. They forget. That's why the election matter. Now different class on its own. They call us sui generis. Now different class. You cannot impose a qualification not imposed by law in electoral matters. You can't. Electoral matter not need for you to get PhD. It don't even need for you to have any certificate, sir, by the constitution. You don't even need to have from a receipt. Now me talk so. The constitution I talk. What the requirement the constitution require is an inability to read and write, and that you have evidence to show that you don't work for 10 years in a place where you were able to read and write and sign your signature. Now it require. You don't require certificate. additional certificate attached to it is mere surplusage, because the constitution say if you have schooled up to. It didn't say if you have certificate. If you have evidence to show that you schooled up to,
then you bring her.
You bring. It didn't even say you should bring it. If you are able to show that you have been educated up to. So every evidence that can lead to show that you have educated up to is enough. But that session even went down and vetoed it down by saying that if the person shows that he has worked for 10 years in a place and is able to read and write, it suffices for him to contest for any position in Nigeria. Until you change that law, you can't impose BSc on anybody to become even councillor.
Okay, so that won't say a guy.
He know the law.
That lawyer called the talk.
He know they there. It's not there.
Okay, no, move wrap up. That one lawyer called the talk say that judge they contradict himself.
The judge no contradict himself. You know, say judge they look at matter holistically. If you take a position like this, you go sure say the position they logically conclusive. But because, for instance, now somebody say APC say Obi does not even have the local standing to fight the issue. Say he was not a member of Labour Party at the time he contested. The court say no, it's not true. That one now the party will determine who be their candidate, and not you, whether he be candidate to or not be candidate. So long as he has been sponsored by his party or by whichever party, it is only the party that will come up, or any person in the party that can challenge him on that ground, that this man not be our member, not an external force, that is an internal mechanism or internal politics of a political party. The mere fact that judge talk that one, e no mean say judge no go fit talk say even though the man na read this thing, if he no do something well, he go say he do am well because he don talk. Say for instance, issue of say you suppose file your witness statement on oath alongside with your petition, but in this case you didn't file it.
Wetin make am that's another aspect.
Yes, may I tell you, you see, I have listened to one somebody's analysis so that this opportunity may correct. Now he say the tribunal at the time where they set am up, e never dey sit where e be say they go fit go to the tribunal to subpoena those people to come to court, and as such the court cannot enforce the impossibility. Now what does that simply seem to mean is that the court should have allowed those evidence to go in, but the person forget to say that the tribunal, that is the petitioner, suppose put their names as their witnesses from the beginning.
Because that was what he just called the talk.
Yeah, so you suppose put them. You suppose put their names, because when they say proof of evidence include but not limited to your witnesses, the number of witnesses sought to be tendered. And in this case, if they will be tendered by subpoena, you go put on there. These people will be subpoenaed, and when they are subpoenaed, because their name is already before court, the court will now subpoena them to come. In such instances, they can give oral evidence. It's a electoral matter. But in this way, they want to bring new facts from the witnesses of these 10 people, which is not a part of their petition. Now the court say no, apart from the fact that time don't pass before you file them, they also introduce extraneous things that is not contained in your pleadings.
Okay.
And people say, you know, see the judge now, in injustice, people one will talk the truth now, the court no let hear them. No. The court cannot allow anything to be dumped into it. For instance, even in normal court, which is not provided in the Electoral Act, if you are out of time, you don't just bring any evidence to the court. You file what they call extension of time. Pray the court that I beg, I not say I'm out of time, but allow me to bring these things in. But it's not there in the Electoral Act.
All right, Dr. Daoud Sani, right? We salute the time we take journal this morning to enlighten people about the position of the law concerning this judgment when we say the tribunal just gave. We salute the time we take journal this morning.